Hello students, welcome back to Nita's Business Studies class. In our last class, we studied about the partnership and its classifications. And in today's class, we are going to study about the partnership deed and the registration of partnership. So what is this partnership deed? So partnership deed is a written agreement between the partners of the firm which specifies the terms and conditions that governs the partnership firm. It provides clear understanding of the roles of each partner. It also serves as an evidence of conditions agreed upon. So partnership deed is something very important agreement that should be entered into partnership firm before the firm starts or before the firm commences. So a partnership is always a business form of business where in voluntarily people come together, two or more people come together, and they set or they form an association, form a business for in order to achieve certain goals or objectives. So in order to enter into partnership, there should be a very clear agreement between the partners in respect of terms and conditions and all the other aspects of partners, how they're going to share the profits, how they're going to share the losses in what ratio, and if later if there is any misunderstanding, how to deal with it. All these matters should be settled. So such an agreement, it can be in oral or it can be in writing, but it is always advisable and is always suggested that it should always be in writing. So written agreement will actually serve as evidence or proof in future. So this is what is written agreement is will serve as very important evidence in future. That is why it is always advisable to have the partnership agreement in writing rather than in orals. So when it is in oral, you can change your word in future, but when it is in writing and signed by all the partners, you cannot change. So it will be an evidence, it will be a proof of your agreement. So the written agreement which specifies the terms and conditions that governs the partnership, it is called as partnership deed. I repeat, dear students, the written agreement which specifies the terms and conditions that governs the partnership, it is called the partnership deed. So when it is in writing, then only it is called as partnership deed. If it is in, it is optional whether you have to go for in writing or in oral, but it is always suggested and advisable to go for in written form of agreement, and that written form of agreement signed and sealed by each and every partner is what is called as partnership deed, and this is going to serve as a proof and evidence in future in case any misunderstanding will take place in future. So now we'll study what are the contents of this partnership deed. So partnership deed should have certain list of particulars, and what are those particulars and what are those contents we'll study one by one. You have to just list it, you need not explain it. So here it comes one by one. The name of the firm, whatsoever is the name of the firm, should be mentioned in the deed very clearly in writing. Second one is the nature of business and location of the business. Yes, what type of business you're having, whether a manufacturing unit or a sales and purchase unit, whatever type of business you're having should be mentioned, and the location of the business, where it is located exactly, which area, which place, it should be mentioned. The third one is the duration of business, for how long or infinite the business is going on, for how long you're going to carry on this business. Duration of the business should be mentioned there. And then the investment made by each partner. So capital investment, whatever money is put in by each partner, should also be mentioned with the amount clearly. Next is the distribution of profits and losses. The clear ratio should also be mentioned in the deed. How they're going to distribute the profits and how they're going to distribute losses in what ratio should also be very clearly mentioned. Then the duties and obligations of each partner. Each partner will have each task to be accomplished. Each partner will have each work and duty to be accomplished. Each partner will be allotted and assigned with responsibility. What are each responsibility of each partner? All these things should be mentioned clearly in partnership deed. Again, we have the seventh content, the salary and withdrawals of the partners. Yes, how much of salary is or drawings is done by each partner, how much of salary is earned by each partner, and what are the drawings of each partner from the firm, from the business, should also be clearly mentioned. Then the terms governing admission, retirement and expulsion of a partner. So what are the procedures and what are the formalities to be followed while admitting a new partner when a new partner comes in, and when an aged partner retires, what is the formality? And expulsion means a partner leaving the firm. What are the formalities? How they're going to make the settlement of amount and assets and liabilities? All these terms and conditions should be clearly mentioned in the deed of each and every partner. Then we have the interest on capital and interest on drawings. Yes, interest on capital, what each partner is earning, and interest on drawings, what each partner is giving to the firm on their drawings, should also be very clearly mentioned in the deed. Then we have procedure of dissolution of the firm. When dissolution means when the firm or the business is ending or closing down, what is the procedure, what are the formalities, and how they're going to settle the accounts. All the other matters should be mentioned clearly when they're going to close down or dissolve the firm. Then we have the preparation of accounts and their auditing. That is also a must. How they're going to, in what pattern they're going to prepare account, and in what pattern, what internal auditing is done or external auditing is done, how the auditing is carried out. All this should be clearly mentioned there. Then lastly, the method of solving disputes. So in case any misunderstanding, any conflicts takes place among the partners, then how are they going to resolve it, or how they're going to solve the problems of each partner, how they're going to settle up with all the disputes, is also should also be very clearly mentioned in a partnership deed. So this is what are all the 12 very important contents of partnership deed. And I repeat, dear students, partnership deed is always in writing. So partnership agreement, when it is in writing or it is in a written form, only then it is called as a partnership deed. Now we're going to study about the registration of partnership. So registration of partnership firm means entering of the firm's name with all the particulars in the register of the firm kept with the registrar of firms. So registrar is a person who has or who maintains the register, and in that register or in that book, the name of the firm will be written with all the particulars, and this is what is called as the registration of partnership firm. However, partnership registration is optional, it's not compulsory. Again, partnership registration is optional, it's not compulsory, but it is better to register the firm. We'll study why. So the consequences of non-registration of a partnership firm are as follows. So in case, of course, it is optional to get your firm registered, but it is better to get registered because of the following consequences. You have certain negative consequences of not registering the firm. So what is that? We'll study. A partner of an unregistered firm cannot file a suit against the firm or other partners. Yes, a partner of unregistered firm cannot go legally to the court of law and file a complaint against the firm or any other partner of the firm. So he cannot do anything, he cannot go for any legal procedure against the firm, or in case of any misunderstanding or dispute, cannot go against any other partners to the court of law. Second one, the firm cannot again file a suit against third parties. Yes, the firm or partnership firm cannot go against the third party. It may be the creditor, it may be the debtor, whatsoever or whosoever. The firm cannot go to the court of law and file a complaint or suit against the third party, that is the outsiders. Then the third consequence is the firm cannot file a case against the partners as well. So the firm cannot go again to the court of law in order to complain if in case of any misunderstanding, in case of any conflicts, whatever takes place. The firm or the business cannot file a complaint or case against the partners. So these are the consequences. You cannot take any legal step against any party. It may be the firm, it may be the outsiders, or it may be even the partners of the firm in case you are unregistered. So these are the consequences of not registering a partnership firm. However, registration is optional, not compulsory, but better to have it registered. So now we'll study what are the procedures what are the steps in order to register the partnership firm. So every time when we are going to register ourselves somewhere, first we have to fill in an application form. So this is what everywhere it's a usual procedure. So first procedure is submission of application in the prescribed form to the registrar. Registrar is a person of firms. The application should contain the following particulars. So you need one application form for registration and you need to fill up all the particulars. And what are those particulars? As usual, name of the firm should be mentioned in that form. Then the location of the firm, where it is situated, which is the area. Next is the names of other places where the firm carries on business. If at all the business or the partnership firm has any other branches, then even that place should be mentioned in that registration form. Then we have the date when each partner joined the firm. That is also very necessary. The date and sometimes even the time is mentioned. The month is mentioned when each partner joins the firm. Then the names and addresses of each and every partner should also be there in the prescribed form in the application. Then the duration of partnership. So how long is a partnership being carried out should also be mentioned. So this is what is all the application form should contain about the partnership firm when you are going to register your partnership firm. This is what you have to fill up in the application form: the name of the firm, the location of the firm, the names of other places where the firms carry on business, the date when each partner joined the firm, name and addresses of the partners, duration of the partnership. And this application form should be signed by each and every partner. Then the second procedure is, we have to very obviously, usual practice, deposit the required fees with the registrar of the firm. So you have to pay the fees required for registration of the firm, pay the fees. And then the third and last proceeding is, after approval, the registrar will make an entry in the register of firms and will issue a certificate of registration. So what happens here is, the registrar, the person responsible to enter the name of the firm in the register, will verify it clearly and see to it that everything is accordingly done according to the law, formalities are fulfilled, and then the registrar will make the entry of the firm's name with the particulars in the register and then will issue the certificate of registration. And once the registrar will issue the certificate of registration after verification and approval, only then your firm is called as a registered partnership firm. So this is the proceeding or procedure for getting your firm registered. This is all for today's class, test students. I hope you have understood. Thank you.